Friends, this is a case relating to Police Act. So, incitement to disaffection, prevention of incitement to disaffection, 1922, Police Act itself, right? So, you may be hearing very recently, about 10 days back or so. So, the City Commissioner of Mumbai, Parambir Singh, he held a press conference and stated that the Mumbai police arrested that Fakt Marathi channel and also Box TV and some others for actually managing the people by giving money to enhance their TRP rates, television rating, TRP, television rating percentage, TRP, right? So to enhance the TRP, if the TRP is actually enhanced, normally they get more advertisements for that purpose. Actually, there is an association called as a Broadcasting Authority, BARC, I think it is BARC, Broadcasting Audience Research Council. Actually, they decide about the TRPs. They have allowed 1800 barometers to be placed in Mumbai, and these people used to give money to certain families per day 400 or 1 month 2000 or like that, and those people will play the channel. For example, it is Box TV. The entire day they will be paying the so Box TV only, so that the BARC knows that will come to know that the TRP rate is very high. And at that time, City Commissioner told that the other TVs like Republic TV, some other TVs, they are also doing the same malpractices, and they will, of course, they will take up the matter, or they will investigate deeply into the matter. Already, you know, there are differences between Republic TV, Arnab Goswami, and also the Congress Party, and also the police of Mumbai, right? So, very recently, who is this man? The Republic TV editor. Republic TV, actually, they have exhibited the news that now the police team, the police people of Mumbai, actually, there is a growing contempt against the city commissioner, and one day it will break. So they have got correct information or strong information that the police force under Parambir Singh, they are not happy and they wanted to rebel against him, and they have got this strong information. It was published on 19th, right? So immediately on 2010-2020, Mumbai police registered against FIR against the Republic TV's editorial team, right? So under section 3 of the Police within brackets Incitement to Disaffection Act 1922, and also 506 of the IPC, because the offences, the publishing of the news, it amounts to the offence amounting to incitement of disaffection, affection or disaffection, so among the members of the police force, right? So, and also against the Commissioner Parambir Singh, and for defaming or downgrading their image in the eyes of the general public. Right? Here the complaint is sub-inspector. He is Sashikant Pawar. Right? So he are basing on his complaint a case under section 3 of the Police Incitement to Disaffection Act, and also 500 is defamation, and 34 common intention was registered in NM Joshi Marg police station against the editorial team Sagarika Mitra and others. Right? So the news publication should be more careful. Anyway, the police case has been registered. Of course, this Republic TV says it is an assault on the media, freedom of press, media rights, and that they will fight every strong arm tactic. They will fight for the same. Right? So this is the situation. They have registered the case. So they have called, of course, since it is a simple case, they might have given notice under 41A. Already a tussle is going between this Arnab Goswami and Mumbai police. He wanted to video conference, they did not agree. They asked him to come to the police station. He was made to wait in the police station. So much things happened, you may be knowing that. Right, now the point is whether this case will stand in the court of law or not, we don't know. But there are certain decided judgments. That's why I wanted to take up this case as out of academic interest. So I want to tell you, discuss a case under same sections registered against a retired inspector of police, Mr. Sengodan, N. Sengodan, in the state of Tamil Nadu. You can refer this case as N. Sengodan versus Secretary to Secretary to State, Secretary to Government, Home. Yes, this is in, of course, actually happened in 1998. Right. Now, let us go into the details of the case. In brief, I will tell you. This Sengodan, he was actually an army officer. After working there for 10 years, he came back and he joined the police service. He retired as inspector of police in the cadre of inspector of police in the year 1997. Right? So, of course, he used to take up the matters of the police department. He wanted to enshrine as a leader before retirement itself. But what happened is, after retirement, on 8/12/1997, he gave a press statement to the newspaper Malay Marsu, stating that the condition of the officers of the police of Tamil Nadu is not good. They are not able to vent out their grievances. They are not able to express their grievances. And to cite an example, he stated the incident on 30/11/1997. A police constable by name Selvaraj or Thiru Selvaraj. So he was attacked and killed in Kovai, and the incident could not be brought to the notice of the government. The women folk of that Selvaraj, they have to come to the streets, they have to stage dharna, and then only the matter was made public, and the government came to know only later. That means there is nobody to represent the police force to vent out their grievances. Therefore, he requested Kalaignar Karunanidhi, who was the then CM, and he praising him that Karunanidhi was he is looking after the welfare of all the people, and he treating them all equally. Then he requested the chief minister to accord permission for the formation of the police union. Right, that means he wanted to be the head of the police union. So the grievances may be brought to the light or to the notice of the government. Right, otherwise they have to fight on the streets itself. We request the CM to accord sanction to form an association to police for the above purpose. So this was taken very seriously this happened in Salem city. Right, he is after retirement, he was staying in Salem. So this has caused ire to the superior officers. Therefore, same thing. So a case under section 3 of Police Incitement to Defection Act 1922 was registered against him along with section 505 IPC. Right, so he was arrested on 8/1. He was arrested of some day 6/1. Yes, he was arrested on 6/1/1998 in Fairlands and kept in Fairlands Police Station, Salem. Of course, he was sent to jail. While he was in jail, before coming out on bail, so he was booked under the so-called Bootleggers Act. So the prevention of activities of bootleggers, then drug offenders, then forest offenders, IT offenders, and land grabbers. 1982 Act is there. So this was actually, as a commissioner, the IG, that means since he has got executive powers, the commissioner of that Salem city, he has obtained the detention order under the Anti-Gunda Act 1982, and it was served on him. Of course, it was signed by the governor also. Right, so he objected for the same. He has appealed against him. A committee of High Court judges has been appointed. Of course, the committee held that detention order will not continue. Therefore, he was asked to go. He can be released on bail. So on 3/3/98, of course, since the detention order was revoked, and he came out on bail. Right, now this is the story. Same thing happened like this. Ultimately, what happened is, so the police, they could not file the charge sheet basing on the findings of the committee. Ultimately, they referred the case. They served the RCS notice also. Now, at that juncture, he approached the Honorable High Court of Madras for compensation, because it is a remedial right under Article 32, of course, 226 of the Constitution. So, he has claimed compensation for his mental agony and damage to the reputation and his affecting towards body and mind. Of course, single judge dismissed the writ petition, even the division bench also, yes, dismissed the same on the ground that the police officers who registered the case and the governor who gave the so-called detention order and the PP who supported, public who supported that the order, all these things. So they have done all their duties in the discharge of official duty, and this man, Sengodam, he failed to establish the malified intention on them. Right? Now ultimately he approached the Supreme Court. Supreme Court held that the state, so they are all acting on behalf of the state, is it not? The state has grossly abused its power, legal power. Actually, they wanted to involve him in a criminal case. After all, what is it? He stated that he wanted an association to represent the grievances of the police people to the state. Is there anything? Is it causing disaffection? No. So they used the power. Not only they arrested him, they involved him in anti-Gunda Act, just like our cinema actor, celebrity Suman. Yes, he was also actually witch hunted by that one in Tamil Nadu. But it's a different issue. Anyway, so the appeal, and therefore they wanted to destroy his reputation, and they don't want any unions in the police department. So Supreme Court did not agree. It allowed the appeal, and they imposed a cost of 2 lakhs on the state to be paid to the respondent, to be paid to the appellant. So that's what I want to tell you is, so Section 3 of Incitement and Defense Act may stand in the court of law, may not stand in the court of law. Of course, it is for the court to decide. Anyway, since there is a decided case law in Tamil Nadu way back in the 1990 itself, I am putting up to you. Okay, let us see what will happen in a Republic TV case. Okay, thank you.